Hi, everyone, and welcome back. I'm Andrew Price, the co-head of the Commercial and Energy Disputes practice at Norton Rose Fulbright.
And I'm Rafe Schaefer, Commercial and Energy Disputes partner in Houston, Texas.
Today, we're going to be covering the amount and controversy requirements for the Texas Business Court, and importantly, some cases out of the court that talk about how they're going to review and analyze whether or not those amount and controversy requirements are met. Rafe, why don't we start by you giving us a primer on what those amount and controversy requirements are?
Sure. So, easiest way to think about amount and controversy for the business court is that there are three buckets. The first bucket involves corporate governance disputes against publicly traded companies. For a corporate governance dispute involving a publicly traded company, there is no amount and controversy requirement. The second bucket is for corporate governance disputes involving privately held companies. For a privately held company in a corporate governance dispute, the amount and controversy requirement is $5 million. And then the third bucket is the catch-all, large, complex commercial dispute bucket that the business court has jurisdiction over. For those cases, the amount in controversy requirement is $10 million. Andrew, you mentioned some of the court's jurisprudence. Has the business court written any opinions on these various categories of the amount in controversy requirements?
It has, Rafe, and we'll pick up on that last bucket you talked about, which is the amount and controversy requirement in quote-unquote large commercial disputes, the $10 million bucket. The 11th Division recently issued an opinion in a case called ET Gathering and Processing versus Tellurian. And in that case, the defendant challenged the amount in controversy, challenged the subject matter jurisdiction of the business court through the procedural mechanism of a plea to the jurisdiction, which I think is the appropriate way to do that. And in that plea to the jurisdiction, the defendant in that case alleged that the petition of the plaintiff, which pled for damages in excess of $10 million, the defendant in that case said that was merely a sham, I think was the phrase used. And the business court applied long-standing plea to the jurisdiction law and plea to the jurisdiction standards in analyzing that question. And essentially, the business court said, look, the plaintiff pled that the amount in controversy was in excess of $10 million. The defendant, in its plea to the jurisdiction, did not come forward with any evidence proving or establishing that that wasn't right, or, as they had alleged, that it was fraudulent or a sham. And so essentially the court said, look, the plaintiff's pleading controls, and in fact the court used the word determinative. The plaintiff's pleading is determinative on the amount in controversy question. And the court reiterated long-standing Texas principles that the court is not allowed to and should not delve into the merits of the plaintiff's claim in determining a plea to the jurisdiction or analyzing the amount in controversy allegations. And so, moving kind of to a different bucket, the business court obviously has jurisdiction over non-monetary cases, cases seeking non-monetary relief like declaratory relief or injunctive relief. In a way that appears at odds with these amount and controversy requirements and buckets that you've outlined, has the business court tackled that issue yet, Rafe?
It has, Andrew, and that's the second case that we're going to talk about, which is C1031 LLC versus John Tarbox out of the 3rd Division of the business court. That case was a pure corporate governance dispute involving a closely held corporation. The only thing at issue in that dispute was whether removal of 2 managers was effective or not. C10 had sued in Travis County seeking a declaration, a declaratory judgment, that removal of those 2 managers was effective. The defendants then removed that case to business court even though there were no monetary claims asserted at all. C-10 sought to have the case remanded to district court, alleging that lack of subject matter jurisdiction because the amount in controversy requirement wasn't satisfied. The court, in analyzing the issue, or in analyzing the remand question, grappled with two key jurisdictional issues that I know we're going to talk about here. First, it looked at whether or not the $5 million amount in controversy requirement applies to declaratory judgment or injunctive relief cases at all. And then second, it analyzed whether, if that $5 million requirement applies, how to determine the amount in controversy issue in cases involving non-monetary relief in the removal context. Andrew, can you walk us through how the court resolved that issue number one?
Yeah, so issue one was pretty straightforward. The court confirmed that these monetary thresholds with regard to amount in controversy do in fact apply to claims for declaratory relief, claims for injunctive relief. So the court is going to look at those claims through the lens of the $5 and $10 million requirements. And so the issue becomes, how are they going to do that? And so what they said was, we're going to measure the value of the claim by looking through the lens of the $5 and $10 million requirements. And we're going to look at the action as a whole, not just on a claim-by-claim basis. So if you satisfy the amount in controversy requirement for the whole of the action, then you have jurisdiction, even though you may not satisfy it on an individual claim-by-claim basis. So that's issue one. How did the court tackle issue two?
Sure. So on issue two, the court, after having determined the $5 million amount in controversy requirement applied, the court analyzed or provided a framework for how it was going to analyze the amount in controversy issue in any given case. Same framework it applied in the E.T. versus Tellurian opinion. It went through the various burdens that it is going to apply. The first burden is a burden of pleading. The court held that the party initially invoking the subject matter jurisdiction of the business court bears the burden of pleading jurisdiction, including amount in controversy. If that jurisdiction amount in controversy is challenged, the party seeking remand or dismissal has a burden of proof to challenge the non-moving party's jurisdictional allegations. If the party satisfies that burden of proof, then the non-moving party, the initial party invoking jurisdiction, has to come back and offer evidence sufficient to raise a fact issue on amount in controversy. And then once a fact issue exists, the party invoking jurisdiction has the ultimate burden of proof at trial or with the ultimate fact finder. And so after setting forth that framework, Andrew, what was the result in the C-10 case?
Yeah, so it's interesting. The court obviously applied the framework that you just outlined, and this was a case involving a small, closely held business. And so in the notice of removal, the defendant had claimed that the $5 million amount in controversy requirement had been met. The court said, I think that's unlikely, and seems skeptical about that. But the court did go on and say, unlikely does not mean impossible. It's possible that the rights that are being implicated in this case meet the $5 million requirement. And so, interestingly, the court said, I'm going to allow for some jurisdictional discovery over a short period of time, and then we will have an evidentiary hearing at which controverting testimony can be received, or affidavits or declarations provided to the court. And to the extent that a fact issue is raised about the amount in controversy, the amount of those rights in question, then the court determines that fact issue and will determine then whether or not to keep the case as to whether or not the amount in controversy has been met. So Very interesting. We haven't yet seen another ruling from the C-10 court about what happened with regard to that discovery or that hearing, but we'll be monitoring it.
Yes, and certainly there's much more to come from the Texas Business Court on this and other issues, but we've really only scratched the surface on issues that can come up involving amount in controversy. We're continuing to monitor the C-10 case as well as the other opinions authored by the Business Court, and we'll keep you updated as the Business Court continues to develop its jurisprudence on amount in controversy.
Yes, and thanks for joining. Please click like or subscribe to the channel to continue to receive our content. Look forward to seeing you. Thanks.